Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Now today I'm looking at a book which has come to us for review from Edinburgh University Press. We've reviewed some of their titles before. It is about Scottish law, but it's a fascinating area which is interwoven, of course, with much wider general legal principles. The book I'm reviewing today is called Trusts and Patrimonies, and it's been edited by Remus Valsan. This book is part of the Edinburgh Studies in Law, Volume 12, and the series editor is Elspeth Christie Reid. Now, my wife Elizabeth and I have looked at this book and had an interesting talk about it. Obviously, it's a fascinating area of study for anyone interested in trusts in particular. We gave it the title, as far as our review was concerned, of The Scottish Trust as a Model for Multiple Jurisdictions Worldwide. This book examines the possibilities. Let's have a look at the book first of all. It's got a red cover. It's part of a series of books, all very similar. There's the spine and then there's the back. You can see at the back there's a lot of detail. It's a hardback. As I say, it's part of the Edinburgh Studies in Law series. The back, let's have a look at the back and the front. It runs to something approaching 250 words. There's not much on in fact there's nothing on the inside dust covers you can see. You've obviously got that at the back. There is a good index which I found at the back, which I shall just get to, which shows you some basic information. You'll be pleased to see that it's actually page numbering that they use. If we go to the front of the book, you can see the Edinburgh Studies in Law series, which is listed there. Then that's the front cover of the book itself. Then you've got the contents section. You can see it's split into various parts. That's the first page there. Then just a little bit over 3 pages in all, and an index at the back. Then you've got a preface and acknowledgements, and then that's actually from Remus Valsan himself. And then you've got a list of contributors, because this is reliant upon a number of people contributing, and of course they are listed in each of the chapter headings at the front in the contents section. Then you've got something I found extremely helpful, which I'm sure anybody who's involved in these jurisdictions will be happy to have, and that's the list of abbreviations, because again it can sometimes be a little bit confusing as to exactly what some of these abbreviations actually mean. Then you've got a table of cases, of course, which is to be expected. Then you've got Dutch and French cases as well, which are listed. Then you have the introduction, and then it goes straight into the subject matter. There is footnoting, which is useful. Quite a lot of it, as you can see, as I go into the middle of the book. There's no paragraph numbering, but you do have, as you can see here, subheads which are helpful to set out the general propositions which are being expounded. And as I say, it's it's a very interesting read, not just from the point of view of the detail in Scottish law, but also a wider readership. You do have concluding remarks at the end of some of the chapters, which I found also of some help. There's the book itself. It's about 250 pages in total. Now, this is what we say about the book. It's always, as I say, always a pleasure to review these works from Edinburgh University Press. They're of a very high academic standard, as would be expected. They also have a lot of information which I think is of great benefit, not just, as I've said later in the review, not just to the practitioner, but also to a much wider readership who are interested in trusts law. This is what we say. Published recently as part of the Edinburgh Studies in Law series from Edinburgh University Press, this book examines the nature of the trust as a fundamental legal concept, and it explores the ways in which trusts and patrimonies interact in various jurisdictions. It will therefore be of particular interest to international lawyers needing to enhance their familiarity with cross-border issues pertaining to trusts. So you can see the wide appeal of the book itself. This apparently is the first book to address systematically the relationship between trust and patrimony. The aim, at least partly, is to determine whether the common law trust can be understood as a civil law patrimony by appropriation, whilst at the same time outlining the advantages as well as the obstacles involved. And the focus is on trusts within civil jurisdictions. Obviously, trusts are, in the common law, known as civil, not criminal matters, but it's specifically civil jurisdictions within the overall concept of the non-common law jurisdictions. Although, as the serious editor points out, the book we think and she thinks would also be of interest to practitioners in common law jurisdictions who are seeking a wider and more internationally orientated perspective on trusts. And that, I think, is the basis, the genesis, if you like, of the book. The editor, Remus Valsan, who lectures in corporate law at the Edinburgh School of Law, heads a team of contributors, which I've mentioned, all of whom offer established expertise in this specialist field. The result is a distinguished collection of papers, some new, others already published, which have been described as key reference texts that have pioneered the trust as a patrimony concept. The longer-term objective is to enhance understanding of the Scottish Trust, not only within Scotland but elsewhere, and that must be important because of the opening of the borders has become a much more international society, in other words, the global village. The implication here then is that the common law trust might be replicated in different jurisdictions using patrimony based on the Scottish model. That is, of course, as the main tool. And when I mention the word common law trust here, of course, I include equity, which is anybody who has studied common law in England and Wales will know is the other stream running with the common law to found what we have as our basic principles of law in England and Wales within the English legal system. I wanted to get that established clearly because some people may not be as familiar with the growth of equity in trusts within, effectively, the overall legal system, with the common law on one side and equity on the other. But that, of course, is for another book. Now, let's go back to this book. Parts 1 and 2 of the book discuss patrimony in the common law trust, as I am calling it, and then patrimony in the Scottish Trust. Trusts and patrimony in France, Quebec and the Netherlands are then examined in part 3. And one could argue, of course, that this book and the research it contains represents a stepping stone on the way to a much greater degree of harmonisation of law and legal systems worldwide, especially, of course, bearing in mind the increasing popularity of the institution of trust in civil law jurisdictions in Asia and continental Europe. And I must say, frankly, that the concept of the trust works. It's a great concept. I'm delighted with it, full supporter of it, of course, and it's nice to see how it's developing elsewhere. So let me conclude by saying a useful aspect of the book is its table of cases there at the front, all or most of which one assumes are illustrative of the book's central thesis. Then, of course, there are the copious footnotes which you get throughout, which are a boon to researchers. So we feel that international private lawyers, judges, academics, and indeed anybody professionally involved in trusts or has an interest in this area should acquire a copy of the book. And the publication date is cited at 2015. I've always been very interested in the concept of trusts. I've taught the law of trusts in the English legal system. There's this book again, the back of it. It's a fascinating area of law. Trusts without equity. Now, I mentioned earlier, and you see there, you do have, by the way, a very nice little short index at the front of each chapter. What you've got here, trusts without equity, I mentioned in the common law jurisdiction in England and Wales that we have the common law and we have equity. But the important thing to remember is where, in fact, the law of trusts has come from. And this book gives you a very useful introduction, which might be quite an eye-opener to people who have not been born and bred, as it were, like I have, on the English legal system. You've also got Patrimony, not equity, the trust in Scotland. So you can see how it's developed in a slightly different way. Then you've got a whole range of other interesting areas. Let me just start at the front. The trust as patrimony, an introduction, and it does explain right at the beginning what is meant. Trusts exist in a multitude of forms across legal systems and traditions. I think that says it all to a certain extent. This is the book again. that point I think is very valid, because there has been a view that trusts only really developed because of the pricking of the king's conscience over the rigidity of the common law all those centuries ago in England and Wales. Not the case. It's much wider than that, and I think this opens up a whole new world for people, and I'd like to thank all the people involved very much for this book. I think it's a great contribution to the concepts of trusts and how they work in the modern era. So thank you to all concerned, and do have a look at the other books in the series as well. Our reviews will be appearing in the journals and on the web. Thank you all to all. Bye bye.